We next have Megan Collins. You can see what her piece is about. And again, you have a familiar face at the table, Professor Linda Meyer. With her is Paul Thomas. He is an assistant federal defender. He's head of the New Haven office of the federal defenders. He is a graduate of UConn. He clerked for District Court Judge Ellen Bree Burns. He was then a partner at Zeldis, Needle, and Cooper for many years with me before he broke my heart and left for the Defender's Office. He has been awarded the Champion of Liberty Award by the Connecticut Criminal Defense Lawyers Association. He is an adjunct professor at the Yale Medical School, oddly, where he is the legal advisor to the Law and Psychiatry Unit, run by Howard Zonana, who might be familiar to some of you. Paul is the son of a psychiatrist and has displayed his own lunacy in the past when, before going to law school, he hiked most of the Appalachian Trail, almost starving to death in the process.
Thanks. So I chose to write my note on the plea not guilty by reason of insanity because over the past few years, well, specifically on the plea in Washington State, because over the past few years in law school, I've been doing research on reactionary legislation. And by reactionary, I mean a law that is put into place because of public reaction to some catalyst event. And so the catalyst event that I was looking at in this case was one in Washington State. I'm going to throw up some headlines. Washington State has a law that when a person is acquitted by reason of insanity, if they need to be committed, they're committed indefinitely to a mental state hospital while they're recovering, and they're allowed to be released at a time that when they've been deemed recovered. In the interim, the state hospitals used to have a program where they would allow patients to have these rehabilitative field trips. They could go to libraries, bookstores, state fairs, and on one of these field trips, because of administrative failures, because of a lack of oversight and a lack of staffing and a lack of risk assessments, one of the patients was able to just walk away from the group that he was with, and he was gone for 3 days. And in the interim, the media picked it up, and the public picked it up, and the public propositioned the legislature, and the legislature enacted a reactionary law. And because the public outcry was so great, this law restricted patient outings in the state hospitals in Washington and limited them to circumstances where the patient is leaving for a medical appointment, a legal appointment, or to attend the sick bed or the funeral of an immediate family member. And that's it. So there are no more rehabilitative field trips. The patients are confined, and they're confined indefinitely. And so to me, this is taking what the law says when someone is not guilty by reason of insanity. It means that they don't have the mens rea to be the guilty mind, to be committed for that offense. And to me, by restricting the patient outings to such limited and specific circumstances, you're essentially confining that person. You're imprisoning them instead of putting them in prison. And I found out about this. I was working at a state protection and advocacy in Florida, and we received an email from the protection and advocacy in Washington State with a link to a video of patient and advocate response to this reactionary law. And the patients formed a group called the Sanka Party, and they began propositioning the legislature on their own. And I wanted to write this note because I wanted to look at the law and to look at possible alternatives to the law because the patients are asking for repeal right now. And rather than just repeating to you what they said, I picked a couple of clips and spliced them together, and I wanted to just play that for you. If it will start. Let's see.
The Sanka Party came about because more and more of our rights were being taken away. Every month, every 2 months, another thing that we enjoyed was taken away.
They used to be able to do things like walk around on the grounds with staff, go to the library with staff, go on outings with staff.
I don't like it. It's demeaning, and it's humiliating, and it's uncomfortable.
We understand safety, but sometimes safety brings, unexpected changes that aren't really beneficial to us.
And so when I saw that, the patients talked about how they wanted they wanted to be able to reach out, and they wanted to have a proactive reform. They wanted to do things in a way that sort of showcased exactly how they thought that they could benefit the community when they were released again. They wanted to show that they were reasonable, that they understood that there were safety concerns, but that they didn't think that the appropriate reaction was confining them indefinitely to such restricted conditions. And my thesis was that while our criminal justice system is recognizing that in the plea not guilty by reason of insanity, you're recognizing that this person doesn't have the guilty mind to be committed, but this isn't translating in practice. And I thought that that was problematic, and so I wanted to look at alternatives because I find that the loss of freedom for these patients is particularly troubling. There is this sort of split path. If you're found to have a guilty mind, you're in the punitive system and you're deemed to need retribution and punishment. And there's supposed to be a separate split for persons who are not guilty by reason of insanity, where you're supposed to be helped with treatment and reintegration into society. And I found that that was lacking because of this law, and I wanted to look at ways of bringing that back into perspective. And what I found was that part of the problem is that there's a misperception that and fear of violence in mentally ill persons because of sensationalized media reports or just lack of understanding and fear of what you don't know. And a lot of the studies that I was finding or citing were saying that the violence in persons with mental illness is stemming from currently manifesting psychotic symptoms and not from, and that can be mitigated with medication and with treatment. And that was something that I found was really important, and that's something that I found that reactionary legislation is missing. When there's this catalyst event and a law is passed in reaction to that, the law doesn't always take into account the fact that this is a symptom. This isn't the person's immutable trait. This is something that they can recover from, and they can re-enter society and become a contributing member. And there's also a misperception around the plea not guilty by reason of insanity because they did a survey. Kansas has actually abolished the plea. It's one of 4 states. And when it did in 1995, they did a survey, and 87% of people thought that the plea was a way to escape punishment and to sort of skirt the system. And really only about 1% of felony offenders use the plea, and only a quarter of those use it and are successfully found not guilty by reason of insanity. So it's not something that is being misused in that way. And that was one of my findings that I thought was important in order to make a claim that this group of people should be treated differently and should be helped instead of punished, because they can recover and they can re-enter society. One of the major suggestions that I made was an improvement to the hospital policies. There was a risk assessment done after the escape, and it was done sort of simultaneously with this reactionary legislation. And I found that if these suggestions that the risk assessment committee made were implemented instead of this legislation, it could have been more beneficial for both the patients while still protecting the interests of public safety and the interests of the citizenry who were concerned with the escape. The reason that that the risk committee found that was because the procedures that the hospitals were using at the time of the escape weren't up to date. They weren't properly implemented. And if they had been up to date and had been properly implemented, and if patients had been subjected to risk assessments and hospital staff had been following the procedures they were supposed to follow, then this wouldn't have happened. So it's not that it's inherently risky to take these patients out into the community. It's that there needs to be more oversight, there needs to be a more careful selection, and there needs to be somebody watching and making that determination from an educated place rather than just sort of taking everyone out or having too familiar of a relationship, and so taking someone because you like them and not because they're ready. And another suggestion that I found was states have been beginning to develop mental health courts that are looking at misdemeanor offenses. And for those misdemeanor offenses, the courts are, instead of looking at just punishing the person. They're looking at correcting the mental health problem that caused the person to commit a criminal offense in the first place. And the belief behind that is that if you address the mental health issue, you can prevent future more significant crimes rather than just punishing them for the misdemeanor, and that it'll be more productive in the long run. And I thought that showed a really beneficial transition in the criminal justice system towards recognizing that mental illness isn't something to be punished. And that's extremely helpful for someone who, like me, is advocating for this different treatment for persons who plead not guilty by reason of insanity, because it goes along with this idea that you can rehabilitate this select group of people. You can help them re-enter society. You don't need to punish them. And these mental health courts are focusing on improving well-being and reducing recidivism, and those goals are both in line with what patients who plead not guilty by reason of insanity are trying to do. They're trying to rehabilitate. They're trying to re-enter. And with the reduction in the stigma and the reduction in public reaction, or the change in public reaction to mental illness, it helps these patients have an easier transition back into the community, which reduces recidivism and in the long run would lessen the burden on the criminal justice system by getting people the mental health treatment that they need. And then finally, my conclusion was that by repealing this reactionary law and correcting the administrative errors that led to the escape, the Washington State mental hospitals could use rehabilitative field trips along with evaluations, medication, psychotherapy, supervised living, and social services. And those are all programs that are being used by the mental health courts in order to transition people back to the community and help correct their mental health issues. Then, by using these, the state of Washington could correct the flaws in the current system and allow for recovery and meaningful reentry. And then I just wanted to close this part of the presentation with another clip from the video because, again, the patients were sort of expressing this on their own. They spoke about, in addition to the surveys that I saw and in addition to the statistics and the risk assessments and the research, these patients are saying this themselves, and I thought that was very powerful. So I'll just close with that. But I have to leave this first.
Reintegration is linked to hope for a lot of patients, including myself. Nobody wants to be here, including the staff half the time. But the thing that keeps us going is the idea and the thought of being free again and being, for me at least, a contributing member of society. And if you don't have reintegration programs that are actively working towards that, it makes it very difficult to get through each day. Yeah.
Change will happen and it's going to happen, but it's very, very slow. And with that, we need people who have the power to change, to step up.
So that sort of goes back to why I thought it was an important topic for my note and why I wanted to write about it and why I think that we can make successful and positive changes to the current law.
I applaud your courage in entering into this area. It is a very, very important area, very challenging, and I think that what you've identified is, in some ways, the tension between a couple of the competing interests that clash in the states that you've looked at between, those who are more oriented towards rehabilitation and treatment versus punishment. The conflict between security, I'll say, interests and sort of recovery in that process. And then fundamentally the problem of what I'll call misinformation and how that can drive reactionary in your terms. I think reactive is a better word because I think reactionary has certain connotations to people of, at least of my generation. It may well apply, but, and so that what you see is in Washington, a legislature driven by one event that seems to be more of a management problem than a legal problem of how things were set up. Implementing something that becomes, in essence, micromanagement of something of a medical issue, that being how to treat people who have been committed, yet who are in the process of staged recovery so that they can securely come back to the community. One of the things you spoke about and mentioned that I've got a question for you about is, under the Washington law, people who are found not guilty by reason of insanity are committed for indefinitely?
They're committed until, if they are deemed to need commitment, then they're committed until they are deemed to have recovered.
And who does the deeming?
It's a, you can appeal there's a panel, a review panel, that evaluates all the state hospital patients once every 6 months, and at least.
If they are no longer such a danger that, so there's an interesting parallel from Connecticut, and it was an event that caused the legislature to react, and it was actually a terrible tragedy in Middletown, which is where the state hospital exists, that houses and treats those who are committed, who've been found not guilty by reason of insanity. And it was evidently a man who shouldn't have been let out, was let out. There was, as I recall, a street festival going on in Middletown, and he stabbed and killed a girl. That would lead to reaction, and it led to reaction that instituted a review board to look at risk in determining when somebody was safe to return to the community, and to do it in staged steps. Really, largely a medical, but not entirely a medical decision, a public review process that has actually been extremely careful and conservative, to the point where, and that was instituted after that horrible event, and they do institute gradual lessening of restrictions. But in effect, it has caused many people who have committed serious crimes to stay in the custody of the Department of Mental Health for longer than they would have in the Department of Corrections. Because unlike a sentence that's fixed for a particular crime, some of the people who are suffering from really severe mental health problems, it's such a chronic problem that a conservative review board is really resistant to making that finding. So the reforms that you have in mind, would they enhance, do you think, the ability of persons like the ones who spoke to get out of supervision and back to the community sooner than later?
I think that they would, because the changes that I was suggesting include, there would be a more of a review board type process before they finally were allowed back into the community. But I think that the incremental steps are beneficial. And right now, I think that it's very difficult, and there was research that suggested that a person with a mental illness who's confined to a building all day isn't going to be able to make significant improvements, and many of these patients do need significant improvements before they can go back into the community. And with the hope of going outside, with the hope of being able to take that small step back, and then with the practice of doing it in small steps instead of all at once, if they were deemed to be able to go back into the community, then I think that will help them. It helps make it a smoother process, and it gives it steps instead of just you're locked inside and now you're back out in the community.
I think that's what has happened in Connecticut. I don't know about the final step of terminating review, but it is a process of gradual expansion of, I'll say, the geography within which the committed person can live, and the reduction of the restraints and oversight that is, I'll say, earned with over time.
Again, I'm so glad you're tackling this area. I thought it was very interesting that you focused on Washington State. predominantly because Washington State has actually been in the forefront of the movement to institute evidence-based sentencing and evidence-based probation restrictions. And they've been trying to move away from this kind of reactive legislation where you're kind of basing an entire statute or entire policy on one incident. So I was sad to hear that even in Washington, which has been kind of this model, working with the Pew Trust, has a wonderful website, you know, has done a cost-benefit analysis of all of these different programs, is still liable to this kind of reactive legislation. And, you know, we've seen it happen over and over in Connecticut where we've had an entire structure overturned because of one incident. And it becomes an easy political tool for legislators to use to stay in office. And great book by Jonathan Simon called Governing Through Crime, where he talks about, you know, how easy it is to use those events to get reelected and to create policies that are very kind of they're not thought through, they're not carefully articulated. So sad that it's even happening in Washington. I wonder, you know, you talk about there's a category of people that are guilty and therefore should be punished. And then there's a category of people who are not guilty because they don't have the mens rea, right? But it may be that that some of the people in that category will never be treatable, right? So I'm wondering what happens if somebody's simply not treatable. In other words, you know, their mental illness is so chronic that they will never be safe outside.
Well, I guess my focus, I didn't want to suggest in my paper that every person with a mental illness can recover and can be back in the community. And I also didn't want to suggest that every person who doesn't qualify for not guilty by reason of insanity is therefore subject only to criminal punishment, because I think there's some room for mental health in the criminal justice system in general as well. But as far as people who use the plea and then there's no hope of recovery, I think there still is hope for treatment, and I think there still is room to adjust some of the policies. Part of what the little documentary clips, what they were coming from, the larger video, was saying that, I mean, they used to have tea and coffee, they don't have that. They used to be able to go in a courtyard, they don't have that anymore. And so these are things that could ultimately be given back to even those patients. So even patients who are never safe to go back out into the community, they might qualify one day to be safe in the courtyard. And that's where a review board of some sort or hospital administration of some sort needs to be making a call as to how much freedom can be, I guess, like you said, earned by each person as they recover. And
ironically, it sounds like under the current practice in Washington, those found not guilty by reason of insanity are under more onerous and more restrictive conditions than prisoners because of the reaction by the legislature. And I think that what happened in Connecticut after that horrible incident resulted in a homicide of a child was the institution of a psychiatric security review board that was, if anything, criticized for being too restrictive. But I think what the benefit of that was for the public was a sense of assurance that that liberty was not casually given, that people who were a danger to the community were not just wandering around unsupervised, and this very gradual awarding of greater liberty as people regained control of themselves. The question about people who aren't going to recover can lead to the problem of them being, the way that Connecticut handled this, you can be committed, you are committed, and you can remain for the maximum sentence that the statute would allow. So for some hypothetical situations that you might face 40 years for a crime where if you pled guilty you'd only get 15. which is not necessarily a good outcome. But I think for let's say it's a 10-year period and there isn't recovery, there are then alternate means for civil commitment for somebody who's really not competent to live alone without presenting a danger to themselves or others, and not in this state hospital setting, but in a less restrictive setting, the least restrictive that the state can pay for it. I was going to ask a question about, but I've lost the thread for a second. If you have,
That's okay, go ahead.
What role did the viability of risk assessment play in your research? Because there's a debate about whether or not you can really assess whether someone is a present risk or not.
So after the escape, a bunch of hospital administration was removed or let go. It's sort of all unclear, but there's new administration, and it's because there's recognition that a major part of this was that hospital administrators weren't paying attention. And there was a risk assessment conducted, or a review panel was convened, and they suggested that there be a risk assessment policy in place. And they suggested that that's something that could be a viable option and could be used. Because looking back at this, the Philip Paul, who was the man who escaped, when they looked back, they looked at him in light of what would have been considered for a risk assessment, and they found that if one had been conducted, he would not have been allowed. It was just because hospital administration was too lackadaisical in their application of the policies and in selecting participants in these outings.
Yeah, maybe Paul. Sorry.
I sort of want to follow up on that. My dad's a psychologist, actually, and worked for many years in corrections, including like parole evaluations, and he worked at the sex offenders unit at Avenel, and until very, very recently. And over the years, talking with him about it, he had said, Joe, I thought maybe what your question was getting to, that from mental health professionals, it's extremely difficult to predict accurately how likely someone is to be violent or to hurt other people, and that the way he often described it to me, and was that even if you, while they were in the confines of the institution, could do some kind of risk assessment, what was really hard was that for many of them, the likelihood of them hurting others depended on the support structure that they would have when they got out, and whether they had a supportive family environment, and whether they would stay on their medications, and whether they could get employed in a way that would keep them from sliding back down. And so that, to me, is a really interesting, or a tough piece of the puzzle. If responsible mental health professionals would say, I can't promise you that this guy or this woman isn't going to hurt somebody if you let them go, or if you let them go out and attend a county fair. And that, I guess I wanted you to comment on that piece with one other piece, Megan, that I think makes this really hard, which is, to me, it seems that it's so skewed. And what I mean by skewed is that the public reaction is so enormous when the bad thing happens, and the bad thing is so bad, and the skewed effect of the enormous impact that has, when you weigh that against the less noticeable and less celebrated impact of people being released and doing fine. You could have 999 folks who have been committed, who are released because of humane policies and rehabilitated and work back into the communities and are doing great stuff. But that doesn't have anywhere near the impact that one bad episode has in terms of a public reaction that encourages legislators to be reactive, or encourages review boards to be extremely conservative, because there's so little upside and there's such huge downside from making a decision that causes somebody to get hurt. So do those factors make sense to you, and how does that factor into the way you would analyze the problem? With one last piece that I wanted to ask, which is, you seem to rely on what you feel is a very strong case that rehabilitation is significantly compromised if there aren't more liberal release policies like this, and how strong is the record of that? do you have like a very strong case that you can make with mental health professionals saying, we do way worse in rehabilitating these folks if we can't take them out to county fairs, as opposed to letting them, you know, like play in the fenced-in basketball court, you know?
Right. So as far as, I'm going to do the last question first because I thought of the answer and I understood that part. And then I'll try and sort through everything else. As far as that goes, I did find research that said that the restrictive, so a jail setting or a parole setting for a person with mental illness is harmful to them. It's detrimental, and it impedes their ability to recover, and they do need more relaxed policies. The research was all looking at it from a perspective of prisons and prisoners and not state hospitals and patients, but I drew a parallel because there wasn't as much research on the state hospitals, considering the fact that the current conditions of confinement are essentially prison-like. And there are mental health professionals who have done surveys that I included in my note that stated that recovery and reintegration are more possible from a mental health perspective if there is a greater focus on treatment. And then, what were your other questions?
Well, the skewed piece of it.
Oh, so the skewed piece, actually, I did want to comment on that as well. So in my case, the patient who escaped went fishing. He walked away from the fair and went camping. And he was camping for 3 days. So the only thing he killed were fish. I don't know. It didn't say. So all of the reports focused on his diagnosis and the fact that he escaped. He walked away because no one was watching him, and then he went fishing. And the risk assessment that they said could have been done in his case was to find out that he wanted to be free so badly because he wanted to go fishing so badly that he was a flight risk. That was his risk was a flight risk situation. And because this one man on one field trip wasn't watched by administrators enough, and they hadn't paid a great enough attention to the fact that he wanted to be out so badly, he went fishing. And then the media reacted to that and focused on his diagnosis and how dangerous he theoretically could have been. So I think that even emphasizes how this one event gets blown way out of proportion in a way that all of the success cases don't, because one man one time walked away from a group and went fishing, and it made people so angry that they called for this reactive law. So.
My question is based on what I remember of my crim law class, which is many, many, many years ago. But I remember when we talked about sort of the purposes of the criminal law, the purposes of punishment. You've mentioned a number of them: deterrence and punishment on the one side, rehabilitation. Back then they didn't talk much about reintegration. I think that's a more recent piece of it. But one purpose I remember hearing about that I don't think I've heard the word come from you is incapacitation. And this kind of goes to Paul's point about, do we need to be clearer about what it is we're trying to prevent people from doing? Can you adequately incapacitate by having them in a courtyard, right? And you might not be able to incapacitate if you take them to a public park. But I just wondered if you could speak to that a little bit, because I've always understood there to be a difference between punishment and incapacitation. One is about doing harm, and one is about sort of preventing harm to others. It seems you could be incapacitating without meaning to punish, and yet it might look a lot like prison. So, and it's a more theoretical point, but can you speak to the role of incapacitation here?
I can try. Yeah. So the reason that I looked at this more as punishment versus rehabilitation reentry instead of incapacitation was the argument that unlike someone who is just a bad person who wants to hurt other people, and that's theoretically unrelated to mental illness, so just a person who's a criminal. Unlike them, a person with mental illness can be treated and can recover, and so can be incapacitated with medication or with these behavior modification treatments. And so my argument that this would be a punishment more goes to, it's a punishment when someone has been treated, has recovered, is no longer in need of incapacitation within walls and is still confined there. So that was how I was looking at it, is that yes, you can be incapacitated by being kept from society, but for someone who doesn't need that, then it's a punishment. And I thought that it was punitive to hurriedly, reactively label all of these people as in need of confinement, incapacitation in a building, when that's not necessarily necessary. That's overly punitive for some.
There are several kinds of incapacitation technologies, and the question is, should, if there's someone who rehabilitation is not an effective form of incapacitation, and they're set up to use a bodily confinement for 4 years is what seems to be constitutional backdrop. They say they prefer to undergo surgeries to reduce as incapacitation, lobotomies, have their arms cut off, be castrated. That would also reduce their risk to others and to themselves. Would that be an unconstitutional condition? Should the law be open to people who prefer freedom, but bodily freedom, but surgery, or as an alternative?
Yikes.
Well, I mean, that has been done, at least with respect to Depo-Provera, the castration drug, and people have been given the choice of using that drug or staying inside. It's been, some courts have said that that's an unconstitutional condition, others have not. And again, in this quasi-voluntary way, if your choice is between being behind bars and being out with this condition, I think many states have allowed things like that. Even to the point, at least in some kind of context, of rather radical surgeries, shall we say. So it's been done. It's not something that I think is an appropriate use of the state power, I would say, but whatever. What do you think?
I'm going to agree with that.
I think that there's a lot of capacity for sort of social engineering in this kind of quasi-voluntary way, which is not quite, you have to say, well, what kind of a choice is that, right?
Can I ask, Paul, have you ever discussed that at the Law and Psychiatry Unit? Do
you talk about Depo-Provera and things like that?
Not precisely. No, we discuss through individualized cases, very much like law school, where you sort of learn broader principles from studying case law until you're studying statutes for different purposes. But you derive principles from cases, and you look at cases, and you try to solve cases one at a time as best you can. I made a note here of, it's a very difficult process because in a way there is a inherent conundrum in trying to have a rational legal system deal with irrationality, which at some level is what we're talking about. So who decides when people re-enter society? The rational people. But they're scared by the populace that in Washington say reacts. We can't let this person out because look what could happen, even though it's 1 in 1,000 that happens versus a much higher incidence of other kind of crime, but kind of crime that maybe we understand better. Doesn't scare us at the same level. It's a very challenging area that you've delved into. And so what's happened in Connecticut, for example, is there's a psychiatric security review board that meets regularly to decide if and when people who've been committed to the state hospital, having been found not guilty by reason of insanity, are now fit to return to society. And they generally employ a staged reentry process with treatment over time, They're, however, extremely conservative. You know, one sort of misstep, and we're worried that we're sending somebody who's, you know, potential danger into the community. And there are some people who are very unpredictable and therefore could be dangerous. And as it has worked out, there are people who have been confined far longer than had they been used, I'll say, traditional defense and lost and been sentenced for the crime they committed rather than committed as NGRA, which allows them to stay in custody for the maximum period that the law would allow if convicted. And very few people get the maximum. So they are often worse off because of the way that law is designed to protect the public.
Yeah, that was something that in looking at this, I at one point was analyzing the comparison between someone who takes, even if you get the maximum sentence for a crime and are in prison, you still have an opportunity to end up serving a shorter sentence than that. You have the opportunity for parole and probation, and to me, I felt like there maybe was room for a comparable opportunity for a person who was in a state hospital for an NGRI plea to have that supervised reentry, to have an incremental reentry. And the difficulty is in comparing someone who just did a bad thing because they felt like doing a bad thing, and someone who did a bad thing because they couldn't control their mental state. And for some reason, as a society, we feel more comfortable allowing the person who just did a bad thing out rather than the person who just couldn't control it. Even if we now have them on medication, we're never willing to fully trust that the medication's going to work, even though as a society we generally accept that someone who chose to do a bad thing once can choose not to do it again.
I just realized that I might have been making a false assumption, but I would assume that people who use the not guilty by reason of insanity plea usually would do so for something really serious, like murder or maybe rape or very serious assault. You wouldn't plead not guilty by reason of insanity for shoplifting, probably, right? Because just the way it
you shouldn't. Because the way that the law in Connecticut works, and I would think Washington, is if you are found not guilty by reason of insanity as a shoplifter, say, I don't know what the statute authorizes, but you are then committed up to the maximum term the law allows.
Right.
And that could and typically, sentences come far below what the maximum is. So right. It's really advantageous, I would say, in cases where you're otherwise looking at a very lengthy sentence already, and you're better off really in a hospital than in a prison. Right. But certainly you'd be better off as a shoplifter serving 60 days than getting a year. Right.
But it sounds like my assumption was right, but that to me seems also part of the reason for the skew.
Well, I think it depends. It's different in different states also.
Yeah. But
Connecticut has a very low incidence of people who raise this defense.
And all of the ones that I'm familiar with have been situations where it was pretty horrific crimes.
Right.
And that's part of what scares us about it or creates the skew. It's that this is somebody who did like a really, really, really bad thing. And if they get out before we're confident, that we fixed what it was that made them do that, that's what people are scared. They're not scared that somebody's going to run off and go fishing.
Right.
The guy who went fishing, what was the crime that he committed that he pleaded not guilty by reason of insanity? It was probably murder.
It was.
Yeah.
So you're right. The case that happened in Connecticut that led to a shift to a much more conservative was, I think it was a killing on the streets of Middletown during a street fair when there was a person who was allowed out on leave and wasn't ready for it, I'll say. Killed the kid. That's kind of incident leads to the reaction that changes the whole balance.
So, building a little bit on a couple of the questions, but getting back to the things that you might be able to negotiate in lieu of being inside. So it's one thing to start removing body parts, but it's another thing entirely to rely upon a smartphone to monitor somebody's mental stability. they're starting to do this as an opportunity or an option for monitoring women after giving birth, to monitor them for postpartum depression. And they've been able to start tracking that there are reliable indicia that perhaps someone is sliding past weird baby blues into full-blown postpartum. And was wondering if in your research they've been looking at in any way of using smartphones, using something like a smartphone that they start with inside, and that they're able to bring that and continue that up, so you at least have one concrete touchstone from what they started with. Have an app for checking in daily, having an app for reminders, having things along those lines. That it's also monitoring, kind of like your Fitbit. Where are you, right? So you already have your geographic location on that smartphone. How are you doing? Who are you talking to? How often are you communicating with other people? And being able to monitor through that, rather than necessarily working through other significantly more, far more significant alterations of people and monitoring of people in that way. Just didn't know if that showed up in any of the research that you did in terms of trying to evaluate whether there are other ways to have a better sense of the 999 who get out, and collecting the data to show exactly how successful they are to do that, to be able to counter perhaps occasionally. And so perhaps aggregating the harm that we're doing to the 999 individuals inside, that I think is what you are arguing, that the harm we are doing to those individuals is more than, as much as we hate to do this kind of equivalent, is more than the death of the one child who got stabbed on the streets of Middletown. It's still not a particularly satisfying calculus, but I think at this point the harm that we're doing to the 999 gets dismissed because we think either they deserved it or we still have a tremendous amount of mental health stigma. And saying that whether or not they deserve it or not, we're okay because that kid was innocent. Right. But these 999, by mere fact of their mental illness, somehow aren't as innocent as that child. So just trying to think through the sort of the technology component and whether or not there's been more opportunity or more creativity in trying to think through those kinds of support systems to start inside and be able to transition with them.
Can I offer you a lifeline?
Yes.
Megan, I think you found your way into an incredibly rich, deep, broad field that is in need of thoughtful practitioners. And that's an incredibly challenging, rich set of questions that you asked. And scholarship is very important in this area, and I commend you for venturing in. I think that the article you're working on could probably be readily broken into about 3, and it's going to be expanding rather than there's no finality here. This is you mentioned Kansas, which did you mention that they've done away with the defense, which is interesting. Kansas used to be the home of the Menninger Clinic, which was one of the foremost mental health institutions in the country, and now it's at the opposite end of the spectrum. So it's an incredibly rich field with a lot of hard thinking required to solve these recurring problems. I want to commend you for it. But I don't know if you knew what you were getting into, but once you're in, there's no getting out.
We should end on that note, because that sounds like the touchstone. Are there any other? I don't mean to cut everybody off. Are there any other?
Can I just ask one final question? I mean, one of the things that really struck me in your paper is that these folks have a vote, unlike prisoners, regular prisoners who generally don't have the vote. And the fact that they are able to get their faces and their comments out into the public and advocate for themselves is significantly different. Do you think that that's going to affect either the politics of this, or does that give you some kind of, or does it at least kind of make them more human and maybe avoid some of the mental health stigma that we're talking about?
I think it definitely helps. I think yeah, they've come a long way. They've gotten, they're able to advocate for themselves in a way that I feel, I think it shows that the stigma is at least a little bit less significant than the stigma for certain groups of people who are incarcerated in a traditional prison setting, because these people have gotten their names and their faces out there, and they have gotten bills proposed to the legislature, and they are able to do so. There is some sort of forward movement for them in their own like self-advocacy.